Hello, everyone. Obviously, today I'll be talking about risk management, and I'm happy for you to ask questions as I go along. So feel free to ask questions. As Ben says, I have showing my age a long history of involvement in medical acute doctors and hospitals and medical practices. I've acted for public hospitals, both in relation to civil claims, that is, claims just brought by a private individual against a doctor that will be heard before a judge in our civil courts, as well as inquests, which are deaths that the coroner has an involvement with. And I actually do the counsel work for inquests, so I've had that experience, and I've also act for private specialists clinics. And I was thinking a couple of months ago about how often it is when things go wrong, and sometimes catastrophically go wrong. It's often quite little things go wrong. It's not something dramatic. I mean, when we think about medical negligence, you often think, oh, well, that's where a doctor operates on the wrong knee, radiologist doesn't pick up something on a scan, but quite often it's systems issues, and even then it's not major things, but they can be quite catastrophic. And it's something that doesn't get ventilated often in the public sphere, because if it's a civil claim, they're often settled. So other than the parties that are involved, no one really knows what's going on. It's different. It's certainly different with inquests, and it's certainly in this state we have a lot of media attention. It's often on page 3 of the advertiser. The ABC always reports on it, and others. I'll talk a little bit more about inquests, but it can be quite a brutal jurisdiction. It's very stressful for doctors. You know, I've literally had doctors have breakdowns in front of me. It's reputational damage. And because it's just time, nobody really wants to be sitting in a lawyer's office having to go through where things have gone wrong. So how do we avoid that? Can we avoid it? Probably not, but how do we reduce it? So I'm going to illustrate what I'm talking about today, or the points I want to make with some cases, and they're my own cases. And I hope they will show you the issues I've seen over the years, and just ways that you may be able to think about either advising their own clients or put them into practice in your own areas. So as a lawyer, of course, I'm interested in liability, how to keep people out of court, if people are sued or they have to attend an inquest, what do we do about that, and how are those things measured? And today my focus will largely be on GPs and GP practices, and that's because there is often an intersection between the potential liability of the GP but also the clinic. So the real standard is just the standards that are released by the Royal Australian College of GPs. Any GP practice or specialist practice that's wants accreditation, they go back to the standards college, and in this case with GPs, it's the GP standards, and they cover everything. They cover from the moment a patient walks into the door till they go. It covers keeping documents, privacy, communication, data, doctors being adequately trained and supported. So we always go back to those standards. Now, usually with GP practices, unusually in GP practices, the doctors in fact aren't employed, they're contracted, they're independent, if you like. So they enter into a contract with the owners of the clinic to do the medical work, and the owners of the clinic, they provide the administrative support, they provide facilities, they provide the equipment, and they'll provide other things too, such as patient documentation, and other administrative matters. Often in those contracts, there will be an indemnity back to the clinic. So the clinic will say to the doctor, if you make a mistake, a medical negligence mistake, we get involved in the claim, you've got to indemnify us. But that doesn't necessarily mean that a clinic can't be brought into an action. And towards my talk, I'm going to touch on Section 60 of the Australian Consumer Law, which I think is slightly tending to change the way we might want to think about any practice where you have a clinic, whether it's a specialist clinic or a GP clinic that's providing admin services, if you like, support services, but not really doing the medical side of it. There's sort of a slight trend in that area. So I'm going to start by talking about a couple of cases. Now, we provided you with a handout, and that's largely because I do apologise with you, these cases are they're a bit detailed, they're a bit finicky because we have in each case we have 2 GP clinics and we have multiple GPs. So I'll try to explain it as succinctly as I can. So this first case is a civil case. So that's a case that's brought by an individual person against, in this case, it was 3 GPs, a hospital and a radiology service. And it commenced, the facts that really led to the claim commenced in January 2016. And it's happened in a large regional South Australian town. Patient was 54 years of age. There was a history of brain cancer in her family. Now, she had a GP that she went to frequently in what I imaginatively called clinic number 2. And on Sunday, I think it was the 17th of January 2016, she didn't see that doctor, and I don't know why, whether it was because it was a Sunday and the clinic was closed or the GP wasn't working. She went to clinic 1 and she saw a doctor there who I called GPA, and it happened to be GPA's last day at the clinic before he went on leave for about 3 weeks. So she came because she was feeling a bit dizzy, she had pain in her shoulder. He examined her and was worried that she might be suffering a stroke. So he sends her to the local hospital. So she needs to go to the local hospital and get assessed there. So she does that. She goes to the local hospital and the doctor at the hospital assesses her and rules out stroke. But he says, I want to carry out some scans. So they do an ultrasound of her shoulder and they also do a CT of her brain and upper part of her body. Now, she's never seen again by anyone in the hospital. She just said, right, I don't think you've got a stroke, you better have these scans, go down the corridor or go into radiology and I'll scans. What apparently happened was there was a code blue in the hospital, which is a medical emergency. So this doctor went to deal with this medical emergency and just got caught up with it. So this woman had the scans and nobody said anything about it, so she just goes home. The radiology clinic does send through a copy of the 2 reports, the ultrasound and the CT, to the GP clinic. And what was unclear was whether or not the GPA, who was his last day at the clinic before leave, actually saw that. But the next day, second GP, who I called GPB, who was actually my client, did review radiology, and on the CT scan, the radiologist had put an asterisk and a couple of paragraphs because there'd been an unexpected finding in this woman's lung. And it said, and the radiologist said, it's good to follow it up, there needs to be further investigation. So my doctor clicks in the computer, I think it's called Hospital Direct Service, on the tab that says discuss, because he thinks that's going to recall the patient, tell the patient. It's going to send a message to the reception area. They've got to get this patient back in. He's got to have a discussion with her about this unexpected finding. And there was a dispute between the 2 GPs as to whether, in fact, that was actually going to result in a recall. My GP said, yes, that's what you do. The other GP said, no, that was never going to work. So the first GP, the one that had ordered the scans, goes on leave for about 3 weeks. The next day, January the 18th, the patient actually goes and sees her usual GP at Clinic 2 and explains that she went to the hospital to have some scans and assessments. She said, oh, I had this short shoulder and they took some scan of my shoulder. So that GP rings up the radiology hospital. They tell her about the findings of the scans. And essentially nothing happens for decisively for about 3 years. A hard copy of the scan does turn up. If somebody puts at the GP clinic one copy, where a doctor has to sign off on having read it. Now, it's not clear when that turned up. Both of the GPs denied that it was their signature, this scan. That's a bit of a minor issue, but it never looks good to have two GPs sort of pointing the finger at each other, but that occurred. About 3 weeks later, it was about the 7th of February, I'm sorry, it was the 11th of February, so by this time the second GP's come back from leave, and he claims he never knew anything about the CT, didn't know that there was an abnormal finding, he's never heard anything again. One of the reception staff rings the patient and says, we need to see you about this CT. And she said, no, I'm back seeing my usual GP, I'm happy, I want to stay. And they say to her, do you know about CT scans? She said, oh yeah, I know that. Now that's of course the major big mistake. She didn't know about CT scans, she didn't know what, and she knew she had a sore shoulder, but she didn't have anything. So the reliance on the patient knowing what they've had, but bearing in mind that she was never told that there was any abnormality in CT scan. The next day, another senior admin staff rings her and says, we just want to make sure you understand about the scan. And she said, yeah, look, I'm happy where I am, I'm still with this GP. Those notes that were made by those two admin staff were put directly into the patient's file. And it was again very unclear as to whether any of the two GPs were alerted in any way that those conversations had occurred. So there was a gap between the information. So then about almost 3 years passes since about December 1811. The usual GP has come to work at clinic number 1. And she's looking through the patient, and she brings the patient with her. The patient follows her. And she looks through the file and comes across a CT scan, and she sees the asterisk saying, problem here, we can't, further investigation. And of course, flies into a panic and arranges for a review and scans and things, which reveals a tumour in the lung. She has surgery and chemotherapy. But eventually it metastasised to a brain. She's terminal diagnosis. So what happens next? Well, of course, court proceedings have to happen next, and urgent court proceedings happen. So what we've really had here is, in one sense, you could, say, look, there's a failure here for the doctors to investigate this, but really it's more of a systems problem. You've got a problem where you've got a doctor going on leave, another one stepping in for him, but when the doctor comes back, nobody filling in that doctor with what's happened. They're both saying, well, the original doctor saying, well, I didn't know, I went on leave and came back and nobody's told me about these CT scans. My guy saying, well, he's that. He ordered them. He's right. The admin staff who have spoken to her, and through all of this, nobody's actually said to the patient, there's a real problem with the CT scan. You've got to, you really do have to come back. You've got to tell your doctor, your usual doctor, that there's a problem. Nobody thought about sending a copy of the scans to the usual GP. Needless to say, that matter was quickly resolved. The only party that got out of it was the radiology party, because I said, well, the GP asked about the scan, the ultrasound, we told her about the ultrasound. I wasn't really happy with it, but at the end of the day, the matter resolved. And that's all we could do. I mean, at that stage, what can you do other than compensate the patient? But I think it's an example of the little things going wrong, which had a very catastrophic outcome for this patient who wasn't very old. It also revealed, I think, that nobody really understood how this medical software worked. Both of the doctors arguing between themselves about this, how and when this recall was going to occur. I really wasn't happy with my doctor, who had classed the recall as non-urgent. It certainly wasn't an urgent one. It wasn't like she had hemorrhage in the brain, but I would have thought it was semi-urgent. I would have thought simply that he should have got on the phone and said, look, there's a problem here, it's an unexpected finding, you've got to come back and see me. And if she didn't want to, then there should have been some direct correspondence with the usual GP. There was clearly misunderstanding or no clarity around where did the responsibility start and stop when the GP went on leave. And of course, you know, the lack of communication between the two GP clinics. Now, the next case, which is also a very sad case, the parents called in a civil court. There's nothing wrong with it. Person called a coroner. It's an inquisitive, what we call an inquisitive system. In civil court is what we call an adversarial system, where you have in this case, the patient putting forward her case. They didn't get back to me. They never told me that I had an unexpected finding in my lung. I lost the opportunity to have that investigated and treated. And I should say, just going back to case one, the medical evidence was that if she had been investigated and treated, she would have survived. Well, she would have survived for probably at least another 10 or so years. So in the coroner's court, it's an inquisitorial system. And if you've ever watched European films or Inspector Rex or something, you might have noticed that the police talk directly to the judge. That seems very odd. And the judge seems to know everything that's happening, and the judge talks to witnesses. Well, that's the inquisitorial system, it's European system. And how it works in the coroner's court is that the coroner has to inquest some deaths in custody. For example, if a prisoner dies, someone under mental health order, so they're in a mental health institution and they die, there has to be an inquest. But he also has a discretion that he can inquest cases if she feels that she could make recommendations that might prevent or reduce the chance of this incident happening again. So in this second case, what had happened is 2 people died from undiagnosed TB. And so there was a double inquest. They were both inquested at the same time. And the coroner wanted to do that because he wanted to raise in the community, first of all, that TB is floating around the community and that doctors need to be aware of it, much more alerted to the fact that people could have TB. And importantly, both of the deaths here, there was a girl of Cambodian descent, and TB is endemic in Southeast Asia, and the other woman who was about 20, 21, a student from Africa, it's also endemic in Africa. So these were two people, migrants for want of immigrants for want of a better word, who came from places where TB was endemic. So he wanted to do this so that he could raise the knowledge of the community and also the medical community that if you're dealing with people that come from areas where TB is endemic, you better have it on your radar because the patient that's coming in could very well have TB. This case was interesting for a lot of reasons. I mentioned before the standards from the Royal College they were referred to because I ended up actually acting for 3 people in this inquest. I acted for 2 of the GPs and I ended up having to act for the clinic. There was also another clinic involved with another GP. But it raised a whole lot of things. It raised about children, what should be done with children, what do you do when the child's been taken to 2 or more clinics. It's not a lot you can do. The coroner didn't blame any of the GPs, but it's just something that you need to be aware in this day and age that people will go to see anyone as soon as they can. In this case, this child was 9 years old. She was, as I said, of Cambodian background. She'd been back to Cambodia as a small baby for about 5 months, and then she went back a few years later for 3 weeks, one of which she spent in hospital, and we never got to the bottom of why she was in hospital. Her mother had a very bad stroke and was essentially wheelchair bound. And there was a father and he had a sister, and the sister was essentially the carer for the children. And she would often take the child to Clinic 1. The father preferred Clinic 2. But the father went back to Cambodia quite frequently. So and if the child needed help, he would take her to Clinic 2, and the uncle's carer would take her to Clinic 1, where she was also a patient, and she was a patient of the GPs. So what had happened here is that I think the first time she'd been seen at the other clinic was in about 2012. She came to this clinic in 2015, and she was seen by, and I don't really have to de-identify this because the proceedings are on the findings are on the coroner's website, but there was Dr. S saw her in September, the middle of 15th of September, middle of September 2015, she presented with a productive cough. Now, productive cough, of course, is a sign of TB, but he wasn't criticised for that because productive cough can be a sign of some lots of things. He sent her off, so he diagnosed an upper respiratory tract infection and also got a blood test, which came back with slightly abnormal. So he really didn't do anything. Just very, very slow. It was put in the medical record, but he didn't follow up. He didn't get her back. She came back in November 2015 with something which we all thought was a bit odd, but she had some bite on her head. It looked like an insect had bitten her, but he didn't, for some reason, he didn't talk about the abnormal blood test at that stage. He did, however, go into her medical record on 2 occasions, once in January 2016, 16, and again in March. Now, they had a system where they had a hard copy of patients that needed to be followed up. The doctors there were told, you've got to, if you haven't come back, you better get into the record, you better send out. And they did it by text message, most of the time by text message. I would go to the carer's number, or if it was an adult, it would go to the adult's phone number. But of course, here we're dealing with a child, so we'd go to the carer's number. So he went in twice and never followed her up. After a certain period of time, the name was taken off this hard copy list. So it was all a bit sort of cumbersome. You had this hard copy list floating around, and that would just, names would go off, and you had this text message thing. And in the medical record, it was really hard to understand what had been done. And what happened is I then got roped into acting for the clinic because the clinic had to put an affidavit for the court, because the coroner threw his things up in the air. So I don't understand any of this. And he was saying to the doctors when they were giving evidence, what does this entry mean? Doc something or other. What does this mean? They couldn't really explain it either. And one of the first doctor that said who was actually a co-owner in the business, but he couldn't really explain it. So we had to do an affidavit, and it's not easy putting these computer things down into writing, particularly if you're not particularly computer savvy, but that's ultimately what had to be done. So, the system of recall really wasn't very good. Another thing that came under criticism was that this child was never weighed. This child was very thin, and that was noted by the second GP, but she was never weighed. And the coroner took a lot of umbrage at that, because he thought, what's the point of really acknowledging this child, slender? I think my GP used the word slender, but without, what does that really mean? And if you don't have a benchmark to follow, how are you going to sort of measure? So she comes back in June 2016 and sees the doctor I was first acting for. The doctor I said, did I say that he was Indian anyway, and he'd had experience with TB patients in India. And he doesn't mention the slightly abnormal blood test either, because he says, well, I've only got 10 minutes to see these people. That's all I'm allocated to. But that was ordered by the other doctor. The other doctor should tell me. She'd been coughing up a bit of blood for over a month. She was breathless. He didn't he had the most appalling notes, so basically non-existent. So he was really reconstructing what he did, and he doesn't appear to have listened to a chest. If he did, he certainly didn't note it down. He said, "Oh, well, of course, if she came back, I was going to do an X-ray. That was the next thing I was going to do." But none of this is recorded. He thought it was a viral infection, but even though it was a viral infection, he put on some antibiotics. Where he was at really, she wasn't fine, but he noted she was slender. He didn't make any link between, well, there's something going on with this, or admittedly it was only a slightly low iron response, but he didn't make any sort of link between that. The next thing that happens in the chronology, before I get to that, he didn't make it really different diagnosis. The notes were really, really pathetic. And I've seen a lot of notes, and these were just really, really bad. And again, in clear breach of the standards of the college, and he was cross-examined about that. So are you aware of that? It's quite embarrassing because he actually is an examiner for the college. And so you've got the coroner saying, "Oh, you aware of the standards?" "Yes." "Well, not." But, bad note taking and recording is a very common, very, very common criticism. Now, the next thing that happened by way of chronology was that the father locks up and decides to take the child to the clinic he prefers, and she sees Dr. Q at this clinic on the 12th of August 2016, and he diagnosed a urinary tract infection. But he notices that the child is almost, I can never pronounce this word, chektik, which means basically starved. Now, he was of Asian background too. He was, I think, a Chinese Malay. And the reason I point that out is because the bloke I was at from Clinic 1, he said to the coroner at one stage, "Well, I've got a son and he's really slim too. That's Asians. Asians are slim." That went down really, really bad. Coroner made findings here. That's not how you do with your disciplinary hair. That child in front of me was a bit like my child at home, so it's all right. Asian children are slim, so that was bad. But this doctor did note that she was almost chektik looking, but he made the mistake of saying he was going to monitor her. She didn't do it. Then, just going back to the first clinic, out of the blue, a text message was sent to the carer of the child, it's called Fifi. But we don't even know why that was, why was this done? Was it done? We don't know why all of a sudden she was going to get this recall text message. And I feel bad that she said, of course, she never got these because they had the wrong number. Now, that in fact was when we did the affidavits and defence morale, show that they were actually texting the right number. And then she was removed from that hard copy list to follow us about 3 days later. Now, we jumped from November 2016, so she saw the other doctor in August. Now we're at November 2016, and she comes back to see my doctor at Clinic 1 because she wasn't gaining weight and she was eating poorly. And then he does weigh her, and it's 22 kilos. And he organised some blood tests, and she by now has very abnormal iron levels. Now, an appointment was made, so the clinic has not just texted the carer, they've made an appointment. But she didn't show up, so it wasn't followed up. So an appointment was made. The next month, Dr. C goes on leave for an extensive period of time from the 9th of December to the 16th of January 2017. When he comes back, for reasons that were never really clear, because again, there's nothing in the notes to, he says, we decided she must have a follow-up appointment. And I should add that I did look through the medical record and of the carer, the aunt, and he had seen her about 3 weeks after I got that really abnormal blood test, and he never mentioned to her, "You better bring Fifi back, I've got to see her." So there's gaps, there's no continuity. So anyway, in January, he says to the staff, "I've got to get her back." And an appointment was made in On that same day, now it might have been cancelled because on that same day the father takes the child to the other clinic, see Dr. Q, and she's 20 kilos now, still looking cachetic. She's not eating much and she's losing weight. So he does the right thing. He writes a referral to a paediatrician. What he should have really done is she should have got on the phone and got an appointment and said, right, there's an appointment with this paediatrician, because that letter to the paediatrician was given to the father and never got to the paediatrician. Now, a couple of weeks later, right at the end of January, the aunt brings the child back to the first clinic. He mentions that a couple of weeks ago, the father had taken her to the other clinic and she said she was due to see a specialist paediatrician in February. Now, 21 kilos, and the doctor this time listens to her chest and there's a call when he realised something terrible was going on with the chest. So he says, right, get her in for a chest, you've got to go straight away, which they do. And the next day or so, he gets a call from the radiologist saying she's going to be in hospital. She's really bad. So they take her into hospital. And it's noted in the medical record things like she's outrageously thin, barely able to, absolutely emaciated. They treat her, they diagnose her. She dies 2 weeks later. So you've really got a terrible, terrible outcome for a very small child. Really, again, because not solely systems issues, because, as I said, the doctor that I was first dealing with, his notes were poor. But he said, I've got 10 minutes, what am I supposed to do in 10 minutes? No follow-up of these abnormal blood tests, appointments cancelled, but not, really getting on the phone saying, look, we've got to do this. He's not recording, whether he's really doing what he says, we don't know because it's not recorded. So he gets slapped around quite badly by the coroner for terrible notes, not putting down a differential diagnosis, not putting down a plan, not following up these things. But he gets some brownie points because at the end of January he does get onto it and listens to a chest and then starts the process. But it's the child's it's too late for the child. And he ultimately was saved from really bad findings because the coroner took a real dislike to Dr. Q for a variety of reasons, partly because he put that bit of a thermometer. So that's another case where you sort of look at it and you think, well, really, what's the problem? The problems here are systems issues. Who's taking responsibility? If you order tests, is the responsibility you then follow that through? Or do you just expect the GP that the person sees next, that GP's going to pick up and comment? Is it sufficient just to be sending a text to someone without them really explaining why they need to be seen, particularly with a child? I mean, it's different for an adult. We can make our own decisions about whether we want to go back and see a doctor, but when you've got a child, you're relying on carers and parents to do the right thing. So yeah. So one of the things the coroner can do, because it's his investigation and his case, is they can run independent expert evidence. And he had a long-standing GP review the matter. And he was very hot to trot on the fact that they never got a proper history about this child. So they didn't know that the child had been back to Cambodia twice, that one of those periods. Then one of them was a long period when she was a baby. It was 5 months. The second time she was in hospital. The father actually and the actually ended up having to give evidence, and neither of them could say why she was in hospital. And he was, of course, critical of the note exam, having to do proper notes, the confusion about who was responsible, having to put, in fact, you've got to send an affidavit before the court to try to explain what the processes are. It's not clear from the notes. People giving oral evidence can't explain what is, what are these strange entries in the notes, which refers to hot boxes, software, just like Dr. Direct was there in the other case. and he did touch on the lack of continuity of care between the two clinics. Now, you can't really do much about that, and he didn't blame either of the doctors for that. But I suppose the only thing you can do as a clinician is you can ask both your questions. Has the child had any examination for it? Has the child had any excellence? That's that sort of would, as an adult, you would hope that an adult would say, oh, well, I had an X-ray 2 weeks ago or something, and that's all fine. Probably the child, that information obviously has to be drawn from their carers or their parent. So I think again that sort of just illustrates how these systems can lead to quite catastrophic events. I mean, I got a claim in the an elderly woman who had diabetes and had to go into hospital because the port where she has her treatment thing was locked, and there was a systems failure, but they weren't able to get the medical record out to look at it before they went in to do this procedure, and they dosed her with something she was allergic to and she died. So, systems issues happen all the time. People don't hear about it, but they happen all the time. These are just things that happen. I remember having a case, and this was years and years ago, where there were two men in a wall. One was called Mr. Williams and one was called Mr. Williamson. And the wrong Mr. Williams got the other Mr. Williams' blood and died. So, that these systems, there were systems issues just happening all the time. So, I suppose what I'm also trying to illustrate is part of the property as a doctor, but part of it's the clinic. Now, when clinics have contracted with doctors, they say, all right, doctor, I'm going to supply you with building, with the equipment, with support staff. We'll send out the bills. We'll keep a bit of the fee, but you'll get most of it. They have usually a contractual indemnity in there, but that doesn't mean that the clinic's never going to be sued. And what often happens is the clinic tries to distance itself from the doctor, because the more they're involved with the doctor, the more the fault they So they don't audit their notes, for example. In the second case where the doctor was writing these terrible 1-line, 2-line notes, it didn't really make much sense. If they were an employee, you'd go in and periodically and audit the notes and say, look, these notes just aren't good enough. But if they're a contract and you're trying to keep your distance, and you don't want to think, oh, the more I'm involved, the more I might get involved. It's illegal. So I don't want everyone to get involved. I just hope that they're doing all the things. But we now have, and I just wanted to touch on, sorry, Uncle, how are we going time-wise?
You're 20 minutes.
Section 60 of the Australian Consumer Law. I'm sure all of you have heard about the Trade Practices Act over the years. That doesn't exist anymore. There's a new act. And the Australian Consumer Law forms part of that act. So this is a legislation passed by Parliament for consumers. And I can't say it's a trend that clinics might be sued a lot more in the future, but it's sort of an almost possible sort of trend in the future. I've certainly got one claim, which I'll go through in a minute, but it's quite obvious in this claim why the clinic's being sued. But the problem with Section 60 is that it's providing a statutory guarantee. It's saying, so you're saying to the consumer, the patient, I'm going to supply services to you, and I guarantee that they're rendered with due care and skill. So there's no defence guarantee. It's like we were talking about the other cases where it's a common law notion of negligence. What was the treatment? Were the services supplied to that patient? Was there a breach of duty to that patient, a breach of duty of care? And then the court, that's judgment, or a court decides, and they decide that by speaking to experts who say, yeah, that would normally happen in Australia. We don't have a problem with that. We think that doctor hasn't breached his duty of care. Others will say, yeah, well, that is a breach of duty of care because they should have done this, they should have done that. But here, you've got in an act, Parliament saying, you are guaranteed that I'm going to have the services that you've been due care and skill. What do you do in those circumstances? My guy that's got 10 minutes to see a patient, he's guaranteed that he's going to do it with due care and skills. That could also apply to clinics too, because as I saw with the first case, if there's a problem with, recalling patients, I've got a clinic at the moment who, and this is a breach, again, it goes back to the GP standards. It's private gynecology clinic where a patient was operated on and she had a bleed very bad, turned out quite a bad bleed and another problem. And she was told to either ring the clinic or come back to the hospital. And she rang the clinic and said, oh, well, we don't have anyone. I'll come. Have to go to the hospital. And that's actually a breach of the standards, not having appropriate cover. So under that, that's a guarantee. They'd be gone anyway, probably, but certainly under that. They'd be gone because it's a breach of the standards by the Royal College, but they'd be gone there too. So it's possible that in the future, consumers, patients will just say, well, I'm going to get a guarantee. Why do I stuff around getting expert opinion to say, this Dr. X or Clinic Y has breached their duty of care, I can just go to the specific patients. Now, the matter I've got is not the normal matter, but you'll see very quickly why Section 16 is being used. I'm acting for a doctor who is an overseas doctor. He came out here in about 2019. He is being sued. Initially, it was alleged that he worked in the GP clinic because he was an overseas doctor. Per the regulator for medical practitioners, says he has to be supervised. The clinic arranged a couple of supervisors, so he's got all his work's got to be supervised. Anyway, in 2020, I think 2021, he sees a patient who's got mental health issues, and she alleges a year or so down the track that they were having a sexual relationship. So the first thing that happened was ARPA got involved, because there's only something like 1,600 text messages for over a 5-month period between them. It's pretty cutthroat. But if he doesn't get insurance, he goes to his medical defence organisation and says, no, I'm not insuring you for having a sexual relationship. No, you're on your own. Now, he's from overseas. He's got nothing. He's got a wife and 4 kids who are dependent on him. He's got a car, and what house he rents, anything else. He's put on gender restrictions straight away, so he can only see male patients, so that reduces his income. Big trouble. But for her, who wants to bring a claim, she's faced, well, I've got a doctor here, there's no gold at the end of the rainbow because he's not insured. What do I do? What do I do? I look at Section 16. I'll get the clinic. I'll sue the clinic, and that's exactly what she's done. She's sued the clinic, and you can see strategically it makes sense because the clinic will be insured, and hopefully that's where she'll recover her extensive damages. Now, what will happen here, I don't know. As I've said, I don't know of any cases yet that have been decided. The clinic, what she has said in her proceedings is, look, you've provided this, that and the other, you render the fees, you keep some of the fees, you've got skin in the game. We say that you fall within Section 16, you've got a guarantee, you've breached your guarantee. They also, of course, arrange the supervisors, and the supervisors may be joined to the proceedings because he was seeing her very frequently, and there were a couple of entry in the notes that suggest there was something a bit going on between him and the patient. So were the supervisors doing the right thing? The clinic's saying, yeah, but really most of this activity took place outside the clinic, at night when they're texting each other all night, when he goes to a place 7 times, I think he went to a house. So they're trying to distance themselves. So it's, in one way, it's not a great example of Section 60 being used, but you can very well see how a judge might be sympathetic, bearing in mind that this is legislation from the consumer's point of view, what the court's thinking about. This is protection of the consumer. She's going to say, look, I don't know what arrangements you've got. doctors. I go to Clinic X, you call yourself Clinic, I just turn up there. I don't know that he's in essence an independent contractor. I don't know. I just go and see him. I don't know any of that. So, you know, who knows which way it'll go? I can't say. It's been suggested that some of these cases might be decided by looking at how much control does the clinic have over the doctor. And the reason for this is that traditionally in law, when you're dealing with independent contractors, you look at the person they're contracting with. Do they control? How do they control this independent contractor? Do they control them by saying, "You've got to work at this place today. You've got to start at 7 in the morning and finish at 3 in the afternoon"? I don't know. The High Court has played, Ben can probably answer this a bit better than me, but the High Court's played around with that control test in recent years. I've tried to go back to looking at, you've got to look at the actual contract to see whether or not this person is really in the nature of an employee or really I've certainly seen one in that I had, yeah. It's written that she was a independent contractor, but she couldn't do anything without getting the permission and authority of the owner of the thing. So it's there. Whether it's going to be used, I don't know. You can see the attraction from a consumer to want to rely on it, but it may not be straightforward. As I said, in the case I've got, it's not your usual case. As I said, some, much of the activity happened outside the clinic, outside the clinic hours. But then again, the clinic got supervisors. Did they get the right? Well, actually, one of them is an owner of the business, owner of the clinic. Is he doing the right thing? Is he really supervising properly? Who knows? So I think it's just something to watch in the future as to whether it emerges. From talking to other practitioners, I've heard that there are a few of these claims with Section 60 floating around. So I wouldn't be surprised if it becomes more frequent in the future. Now, how do you insulate yourself from liability? Well, it's very hard. It's a guarantee. Again, it goes back to risk management. All you can do is make the systems as fail-safe as you possibly can. So you can say, well, we did supply services within appropriate due care and skill. But as we've seen from here, how often does that not work out? So, defending some of these claims, both the doctors and clinics might become really in the future. But I can't say, and I know it sounds like a big cop out, but that's because it is a big cop, because I really just don't know how these claims are going to be dealt with. I mean, you could have a situation where you take the second case, the coroner's case, the doctor might end up saying, well, actually it's the clinic's fault because they only allow me 10 minutes. I've got to see patients in 10 minutes, That's their control over me. They're telling me I've got to be here, I've got to start work at this time, I've got to finish work, and they're telling me you've got to just keep seeing people every 10 minutes. So, what do you expect me to do? No wonder I don't write any notes. I haven't got any time. I'm trying to see them, find out what's wrong with them, examine them, write out a few scripts or refer them. That's 10 minutes, if not more. So you can see where this is a bit fluid. I think I'll better stop there. I'm getting older. Does anyone have any questions, any queries? I see you're a bit shell-shocked now. You're rolling over the town.
Okay, studies like they certainly bring it to life. I spend a lot of time going to practices and doing risk assessments and things like that with practices. And it's very clear that lots of practices don't meet lots of standards. If you look at the standards, there's something like, I think the list that we use for our risk assessment is 320 odd standards. Pretty hard to.
Well, I was talking to a practitioner who said that so many practices are accredited, but when it comes to like the non-Japanese ones, they're always in breach. And I don't think there is that time element, but I don't know how you get around that. I mean, 10 minutes really just isn't long enough. I said to my doctor, that is not a defence. You can't go and say to the coroner, I only had 10 minutes to deal with this child. I've got time to wail. He said, well, that's not a defence. You've got you know, if it means you've got to make notes and stay behind and spend a half an hour at the end of the day or an hour catching up, you know, well, it's going to be an hour well spent because he was in the witness box for almost 2 days. That's 2 days you don't want to be in the witness box. Not to mention how much time you spend in my office. But you know, that's the reality. The coroner's court is a very high. It's a council of perfection. They don't care that you've got 40 patients to see. I've done inquests involving, you know, emergency departments, and they'll say, but look, you know, this was one patient, but you know, I've got 40 others. They're not in. Coroner's not interested in those 39 or 40 patients. He's interested in the dead person that he's inquesting in front of him. So, you know, I don't know. It's difficult, but some things we just can't resolve. But that's the difficulty of medical practice these days.
I just want to take the opportunity to thank Joanne for coming along and giving the session today. It takes a lot of time and effort to prepare these sessions. Certainly, take away from me is how businesses that we operate for professions. So that's the end of the second session today. We do have a third session as part of our medical series that's coming up next month, and I'll be talking on that occasion in relation to the federal government's changes to its federal workplace laws. So if you've got the time and you're available, that's an advantage. It's for the occasion. Thank you very much.